Hello, hello, hello. Hello, hi everybody. Hello. Welcome in. It's my full-on Tubing Tuesday tonight. Hello, Cynthia, Kimberly, Alan, uh, Doughboy. You're so crazy with your names. What are you doing? Miss Julie, hi. John, hello again. Dania, hello. Ali, welcome. Katie, hello. Suzanne, hello. And Dawn, good evening. Good to see you. Kathy, hello. Donna, hello. Welcome in, everybody. Yes. Oh, it feels like forever. Although I was on the tube with Falcon and Wiseacre last week. That was super fun. That was a lot of fun. I had a lot of fun with that. With that situation. So, but always good to come back over here. No obligations. All right. Oh dear. Get the YouTube notifications, but really, the TikTok notifications aren't coming on. Oh, that's interesting. Popak just posted an order from California Newsom case regarding discovery for violations. Really? All right. Oh my goodness gracious. It's all coming down at the same time. People can be deported to a third country. Right. So it's a bit more complicated than that. It's not really a affirmative order. What they have said is that the stay put into place with the requirements regarding going to a third country is not going to be needed. So they're saying until this case gets decided, the judge's requirements of the lower court are not in play. That's kind of how it went down. Hello, Tia. Hi, Deb. Oh, I hope not. My camera is definitely better over on the talk, but hello, John. Welcome in. Yes, it sounds really all right. Yes, hoping I do this one. Well, yeah, I mean, oh my gosh, this is pretty big, pretty major what's going on here. The situation's really getting a lot of it's getting out of control. It's getting out of control, everybody. The train's getting away from us here. Oh, your first YouTube. Well, welcome. It sounds better on your iPad. Okay. I need some hope again. All right. Well, we had a win. Today. We had a final decision made on one of our cases. Let me see if I've got it. I didn't have it listed up here yet, but federal grants. Was a federal grants case where they're saying stop taking all of our money, and the court's like, we agree, stop taking all of their money. Don't, do what you're supposed to do under Congress. So that was a win. So we had a win and we had a preliminary injunction put into place today. So those are a couple of good ones. Yeah, it's out of control. I agree. Earlier today, I started cheering, yay! Well, we'll have to see how it plays out here. Who is, I don't know. And anytime I hear that, I don't know if anybody else did this. Maybe I'm just super old, but when back in my day, when we played pool, we always had like big balls and little balls. And so every time I hear that, I'm like, is he like some pool shark? Like, what's going on there? What are you doing, man? He was in DOJ. Yeah, I mean, we certainly don't have any experience, of course, but who needs experience when you can just, do whatever you want? But he was in DOJ. Okay. So the other thing too, though, is without any experience, you can screw a whole bunch of stuff up, but you may not realize how slow everything works. Right, the hacker. Yep. Yeah, boy, I haven't played pool in a while now. My gosh. Those were the days, right? When you could just go out and have a little fun. You didn't care if the world was on fire. You're like, who cares? Give me another pint. Those were the days. That was a long time ago. All right, everyone, welcome in. Welcome in. Good to see you all. Isn't the Doge thing pretty much done now? Well, that's a good question. We still got about a dozen lawsuits against Doge that are still making their way through the system. So those cases have not been dismissed. And that's one thing to really kind of keep in mind. And I've said this too with the Abrego Garcia case. Is just because there have been major changes, you can't take it back. There's no take backs. Like, your bad behavior is already out there. Like, they're asking for sanctions in the Abrego Garcia case for discovery. When they were being such jerks about the discovery, they're like, we need sanctions for that. And Elon Musk tried to get out of one of the Doge cases that he was listed in. And the court's like, no, you can't get out of this. It's like, well, I'm not even there anymore. It doesn't matter. Whatever actions you did that were unlawful or that are being charged as possibly being unlawful, you can get sued for that. And it can take years. I mean, and I don't think maybe Musk realizes this, is that, he's going to be dealing with these lawsuits for the next 5 years. Like, he's not going to be able to get away from it. He's like, oh, I'm not here anymore. I'm not doing anything. It doesn't matter. He's going to be called in as a witness in all of these cases. He's going to be pulled in for depositions, interrogatories. He's going to be, in and out of court for the next 5 years, just dealing with his 4 or 5 months that he was in Doge. That's the legacy of the criminal and civil system. That's how that goes. Right. As permanent positions, it's a weird situation. Touch. Oh, sure, of course. We're all in this together. It's a mess, but we're all in it together. We can get it cleaned up. No Diddy trial here, not yet. I'm gonna kind of wait until things shake down so I can get a final situation on the Diddy case. And also, we're at almost 300 lawsuits now against the administration. So with 300 lawsuits, the executive orders were at, I think, 175 executive orders, plus the Supreme Court cases that are still coming down and being decided. Like, I'm maxed on my caseload right now. Yeah, the same dudes. Well, right, exactly. Frustrated, it keeps pausing. Oh no, Kaya, no. Skateboarding across for charities to help with. No, I'm not seeing that. I think that's amazing though. Good for them. Good for them for doing that. All right, everyone, here we go. Let's diving into the pool here. So tonight I wanted to go through the, the letter or whatever that was sent to, it looks like a letter. It says, Dear All. The letter that was sent to Inspector General, U.S. Department of Justice. Again, these people are really not reliable right now. But these two, and then Chuck Grassley, who is 200 years old now, and Durbin, ranking members, so the Committee on the Judiciary, Jim Jordan as the chair, and Jamie Raskin, ranking member on the U.S. Committee on the Judiciary. So they have sent this to the Senate and then to the House as well. Everyone donate to the closet. Oh my gosh, that's so funny. Really, come on, right? Come on. Right. In real life, and he fell asleep mid-convo. Right? How can you not? That man should be at home with his grandkids. Anyway, well, whatever. Life's about choices. So they've sent it over, and this is coming from the Government Accountability Project here. And so we've got this big written piece. Let me get my sticky note out so everyone knows what I'm talking about as I go through this. So I'm just going to be reading through. We've got 27 pages, so I don't know that all 27 need to be explored. So we'll kind of skip around and get to the highlights here. But this is pretty groundbreaking. We've talked about this many times, that the DOJ has been compromised and we've got some issues. And so now it's like we officially have something. And I think it's because there are hearings coming up. I think Bondi was in some kind of a hearing earlier, or like yesterday. Man, she's a piece of work, that one. So here we go. We're going to just call this the protected whistleblower. Protected whistleblower disclosure here. That's the other thing too, is if the people you're targeting, like the law firms and lawyers, if you're targeting them, like lawyers, we don't just are like, well, that's too bad, sucks to suck, I guess we're out of a job, we gotta go do something else. No, they withdraw, they gather resources, and then they come and get you. Right? So that was one thing too that I've always kept in mind, is with these inspector generals and with these different attorneys that have been pushed out of the DOJ in different various places out of the federal government, they're not going to just be like, okay, see y'all later. No, they're coming back. They're going to come back. Oh my gosh, and they sure are. In a lot of ways, because we, again, you have to be a bit of a fighter in order to be an attorney, because our system is so adversarial. So this is the disclosure of Erez Ruveni here, and I believe he was the one in the Garcia case that said we made a mistake. So he is a long-time veteran of the Department of Justice. So he's been there quite a while, and he's got some stuff to say. All right, regarding, and then we'll just do regarding the DOJ. All right, DOJ, and then we have the 24th here. All right, so hopefully we've got some. Oh my gosh, Bondi really pulled. Oh, I know. I couldn't watch it. I could not. It just was like so awful. He's the one who let it slip that they made a mistake. Right, and that's what changed the whole course of this case. Brego Garcia would not be back or even be making news if it had not been for this attorney. All right, so let's go ahead and dive in. Here we go to the state and the House, or the Senate and the House. We've got protected whistleblower disclosure of Erez Ruveni regarding violations of laws, rules, and regulations, abuse of authority, and substantial and specific danger to health and safety of the Department of Justice. Dear all, we, the Government Accountability Project and Gilbert Employment Law, PC, represent Mr. Erez Ruveni, formerly the Acting Deputy Director of the Office of Immigration Litigation, OIL, of the Department of Justice, DOJ, and a whistleblower. Mr. Ruveni presents the following disclosures to your attention for your respective offices to take appropriate oversight action. All right, between March 15th and April 5th, Mr. Ruveni, almost immediately after receiving notice of his promotion to serve as Acting Deputy Director of OIL, became aware of the plans of DOJ leadership to resist court orders that would impede potentially illegal efforts to deport non-citizens, and further became aware of the details to execute those plans. Now, as an attorney, I'll tell you right now, you are required to report this. If this is going on ethically, you have to report it. There's really no choice. On April 4th of 2025, after raising concerns internally to his chain of command for nearly 3 weeks regarding the government's compliance with court orders and candor to the court, Mr. Ruveni appeared before Judge Paula Zenas, United States District Judge in the District of Maryland, on behalf of the government in the case of Kilmar Brego Garcia. During that appearance, Mr. Ruveni candidly and truthfully informed the court, based on the evidentiary record, that Mr. Brego Garcia's removal from the United States was a mistake. Later that evening, Mr. Ruveni refused directions from a superior to file a brief misrepresenting those facts to the court. As a result, Mr. Ruveni was put on administrative leave on April 5th, and his employment was ultimately terminated on April 11th. It's just so horrific. These people are just bad people. Bad people, everyone. Number one, through counsel, Gilbert Employment Law and Government Accountability Project, Mr. Ruveni has filed an appeal alleging that his no-notice termination violated the Civil Service Reform Act and the Whistleblower Protection Act with the Merit Systems Protection Board. And good for him for doing that. In this letter, Mr. Ruveni exercises his rights to make disclosures to Congress, the DOJ, OIG, and the OSC pursuant to 5 U.S. Code Section 2302 and 5 U.S. Code Section 1213. Mr. Ruveni's disclosures detail violations of laws, rules, or regulations and the abuse of authority by the DOJ and the White House personnel, as well as the creation of substantial and specific health and safety threats to non-citizens. These high-level governmental personnel knowingly and willfully defied court orders, directed their subordinate attorneys to make misrepresentations to the courts, and engaged in a scheme to withhold relevant information from the court to advance the administration's priority of deporting non-citizens. Since April 5th of 2025, it's been widely reported that, according to the DOJ sources, Mr. Ruveni was put on administrative leave by the DOJ for allegations of failure to follow a directive from his superiors, failure to zealously advocate on behalf of the United States, and for arguing against Homeland Security and the State Department when he truthfully represented to the court Mr. Abrego Garcia's removal was in error. This is such a huge situation. I mean, I can't emphasize this enough. An attorney goes in, speaks the truth, is candid to the court, which you're required to do ethically, and then you're fired. Like, this is just, that's crazy. These statements by Attorney General Pamela Bondi and her deputy Todd Blanche are false and misleading. Indeed, it has been since reported that prior to the April 4th hearing, senior counsel to the Secretary of Homeland Security and Trump appointee James Percival conceded that Mr. Abrego Garcia's removal was an administrative error, not that we should say publicly. Nevertheless, White House officials have publicly disparaged Mr. Ruveni to justify their refusal to comply with the Constitution and with court orders. White House Deputy Chief of Staff Stephen Miller falsely stated, the only mistake that was made is a lawyer put an incorrect line in a legal filing, yikes, and labeled Mr. Ruveni a saboteur, a Democrat. Referring to Mr. Ruveni, President Trump stated, quote, "Well, the lawyer that said it was a mistake, was here a long time, was not appointed by us, should not have said that, end quote. Oh, it's so awful. What has not been reported to date are Mr. Ruveni's attempts over the course of 3 weeks and affecting 3 separate cases to secure the government's compliance with court orders and his resistance to the internal efforts of DOJ and the White House leadership to defy them through lack of candor, deliberate delay, and disinformation. Discouraging clients from engaging in illegal conduct is an important part of the role of a lawyer. Again, that's part of our oath, right, that we take. Mr. Ruveni tried to do so and was thwarted, threatened, fired, and publicly disparaged for both doing his job and telling the truth to the court. Because his clients engaged in unlawful activity, abused their authority, created substantial and specific threat to health and safety, and because the pattern of this conduct continues to this day. And it looks like we've just got citations here from various cases and websites. Mr. Ruveni is exercising, let me make sure that's right. Yeah, exercising rights under 5 U.S. Code Section 2302 and 5 U.S. Code Section 1213 to report wrongdoing. Since his unlawful termination, 6 members of Congress have written to Attorney General Bondi and Deputy Attorney General decrying the Hobbesian choice DOJ leadership has created for attorneys who may be forced to choose between their jobs and their oath of candor to the court, and calling for Mr. Ruveni's reinstatement. We thank these members for their support of Mr. Ruveni and urge all members of Congress committed to the rule of law, along with the DOJ Inspector General and the U.S. Office of Special Counsel, to investigate the disclosures presented in this letter. Yes, so we're going to have to see again. Yeah, Stephen Miller. Remember, everyone, Stephen Miller is not an attorney. He is not an attorney. Let's just make sure that's clear. Right. Oh dear. Oh goodness. All right. Am I still here, everybody? Are we buffering or can you see me? All right. Looks good. Okay. Thanks, Willie B. Thank you. Sorry, my internet went down, so I'm on my cellular data. All right. Here we go. All right. Yeah. Sorry about that. Sorry. With the Hobbit. I don't know. I always like the Hobbits. One ring to rule them all. Yeah, that's true. All right. Here we go. Number 1, Erez Ruveni, nonpartisan, zealous advocate with a distinguished... I'm falling apart here, everybody. I'm falling apart. With distinguished service at DOJ. Here we go. Oh my gosh. Right. Go after the hobbits. Before his unlawful removal from federal service on April 11th, Mr. Ruveni had an exemplary, nearly 15-year legal career at DOJ. Mr. Ruveni began his career at the Office of Immigration Litigation, OIL, District Court Section, DCS, in 2010 as a trial attorney and was promoted multiple times under both Republican and Democratic administrations. Most recently, Mr. Ruveni served as the acting deputy director for the Office of Immigration Litigation, responsible for all of OIL's immigration litigation arising in the U.S. district courts nationwide, overseeing over 100 attorneys handling hundreds of cases. See, this is someone you don't want to get rid of. He's like someone who is really important. I can't drink one. Oh my gosh, so true. All right, so supervisory responsibilities included oversight of the government's defense against many significant legal challenges to multiple executive orders signed by President Trump, and defending multiple immigration policy initiatives on behalf of the Department of Homeland Security, Department of State, Defense, Labor, and Health and Human Services. Mr. Ruveni received notice of his promotion to that role on March 14th, effective Friday, March 21st, and in the following week alone oversaw and defended the government's position in at least 7 cases involving motions for temporary restraining orders or preliminary injunctions seeking court orders enjoining the Trump administration's policies nationwide, including multiple emergency appeals to various courts of appeal. Prior to Mr. Ruveni's termination following his candid and truthful representation to the court in the Abrego Garcia case, Department of Justice leadership under Trump administration had consistently lauded Mr. Ruveni's work. For example, in a March 21st email announcing Mr. Ruveni's recent promotion, Deputy Assistant Attorney General Drew Ensign remarked that Mr. Ruveni is top-notch litigator who's taken on some of OIL's most challenging cases over the past nearly 15 years, including as assistant director for over 7 years and multiple stints as counsel in the Civil Division front office, having led and litigated complex cases protecting our immigration authorities, developed sanctuary cities affirmative cases, and worked closely with our many excellent attorneys handling district court litigation. Additionally, Mr. Ruveni's most recent performance review under the prior Trump administration was stellar. Then Deputy Director Colin Kaiser wrote that, quote, Assistant Director Erez Ruveni continues to be one of OIL DCS's, OIL District Court Section's premier litigators and supervisors. He's an outstanding attorney, legal writer, and oral advocate. He continues to handle some of the section's most difficult and highest profile cases. Mr. Kaiser further noted that Mr. Ruveni routinely received accolades for his efforts from senior personnel within DOJ and the agencies he advocates for. Is an indispensable asset to OIL DCS, the Civil Division, DOJ, and the many client agencies he works closely with, and has truly earned an excellent rating for this rating period. So he was really well placed and was given lots of different accolades, apparently. They were doing when they paid for that. Oh my gosh, of course, of course. Indeed, Mr. Ruveni has received an excellent rating for every year he's worked at the department since 2010. On top of that, he's a recipient of 9 Civil Division awards, including 3 during the prior Trump administration for helping lead the COVID-19 immigration litigation response team in 2020, leading district court litigation on behalf of the sanctuary cities litigation team in 2019, and leading defense of the Protecting the Nation from Foreign TORS entry executive order in 2017. So court litigation on behalf of sanctuary city litigation. All right. So he's got a lot of credentials here. For years, Mr. Ruveni oversaw the defense of immigration priorities, regardless of political party. During the first Trump administration, Mr. Ruveni led the defense of the administration's initiatives, including the executive orders and proclamation barring entry of certain nationalities to the United States, multiple rules barring access to asylum to migrants at the southern border, including the entry, transit, and criminal asylum bars, the migrant protection protocols, and the defense of the expedited removal statute against the constitutional challenges. Mr. Ruveni also led an affirmative suit challenging the state of California's laws alleged to interfere with federal immigration enforcement efforts. During the Biden administration, Mr. Ruveni defended multiple immigration matters, including several rules barring access to asylum to those arriving on the southern border. Earlier in his career, he defended multiple Obama-era labor and employment regulations, as well as detention and removal policies and procedures. But before his abrupt termination, Mr. Ruveni oversaw multiple high-profile Trump administration immigration initiatives. So he's saying, like, I did all the work. I didn't care who the boss was. In short, Mr. Ruveni has been a tireless advocate on behalf of the interests of the United States for years, with a stellar record of advocating successfully on behalf of multiple presidential administrations, both Republican and Democratic. To suggest Mr. Ruveni is anything but a zealous advocate for the United States who takes his oath to uphold the Constitution seriously is both false and outrageous. So, I mean, we don't know yet, and I'm sure this will come out, but who do you think Mr. Ruveni voted for? I'm curious. Who do you think he voted for in the election? I'm just wondering. Which way do you think he went? Okay. Yeah, which one do you think he voted for? I'm just curious. Okay. Okay. Interesting. Okay. All right, it looks like slightly more people think he voted for Trump than Harris. Right. Well, I mean, I don't know that we'll ever know. I say taco. I don't know if we'll ever know, but I think that's something interesting to think about throughout all of these cases and things that are going on, especially with regards to immigration. I think it's very important to think, well, which way do you think this particular person voted? Not as some means for a punishment, but just, immigration was this huge issue in the election, right? Right. All right, March 14th of 2025, DOJ leadership expressed intent to ignore court orders to effectuate removal flights under the Alien Enemies Act. Now we're going to start wading through. On Friday, March 14th, Mr. Ruveni received notice of his promotion to acting deputy director of the Office of Immigration Litigation. That same day, following news reports that the president intended to sign a presidential proclamation invoking the Alien Enemies Act, Mr. Ruveni was summoned to a meeting by Deputy Assistant Attorney General of Oil, Drew Ensign. At the meeting were Principal Assistant Deputy Attorney General Emil Bove, Counselor of the Deputy Attorney General James McHenry, Associate Deputy Attorney General Paul Perkins, Ensign, Acting Director for Oil, and Mr. Ruveni's Direct Supervisor August Flengy, and other oil attorneys. At the meeting, Bove indicated to those in attendance that the AEA proclamation would soon be signed and that one or more planes containing individuals subject to the AEA would be taking off over the weekend, meaning Saturday, March 15th and Sunday, March 16th. Bove did not provide further details and redacted. Bove indicated redacted again and stressed to all in attendance that the planes needed to take off no matter what. Bove then made a remark concerning the possibility that a court order would enjoin those removals before they could be effectuated. Bove stated that the DOJ would need to consider telling the courts F you and ignore any such court order. Mr. Ruveni perceived that others in the room looked stunned, and he observed awkward, nervous glances among the people in the room. Silence overtook the room. Mr. Ruveni and others were quickly ushered out of the room. Notwithstanding Bove's directive, Mr. Ruveni left the meeting, understanding that DOJ would tell DHS to follow all court orders. Mr. Ruveni was stunned by Bove's statement because, to Mr. Ruveni's knowledge, no one in DOJ leadership in any administration had ever suggested the Department of Justice could blatantly ignore court orders, especially with an FU. Mr. Ruveni was in disbelief because, on the contrary, the Department of Justice consistently advises its clients of their obligation to follow court orders, not to ignore them. Mr. Ruveni knew that it was absurd and unlawful to do otherwise, a proposition that Mr. Ruveni felt even more certain of after a brief conversation with his supervisor, August Flentier, shortly after the meeting. Oh, I can't even imagine. Like, we're not going to follow court orders. Like, what? Number 3, between March 14th and his unlawful suspension on April 5th, Mr. Ruveni refused to obey an illegal order and made protected whistleblower disclosures. So this is where we're really getting into the meat and potatoes. Mr. Ruveni's disbelief following the meeting with Bove is now a relic of a different time. Over the next 3 weeks, Mr. Ruveni was involved in 3 separate cases involving the legality of the administration's immigration removal operations under its newly implemented priorities, during which time he directly witnessed and reported DOJ officials undermining the rule of law by ignoring court orders, DOJ officials presenting legal arguments with no basis in law. That's a true story. High-ranking DOJ and DHS officials misrepresenting facts presented before courts, and DOJ officials directing Mr. Ruveni to misrepresent facts. In one of these cases, in violation of Mr. Ruveni's legal and ethical duties as an officer of the court. Mr. Ruveni's internal reporting and ultimately his refusal to obey this illegal order directly resulted in his suspension and termination. JGG v. Trump. Flights departed the U.S. through invocation of the Alien Enemies Act during issuance of an injunction, with government claiming oral injunctions are not binding. All right, there we go. We're going to start peeling this apart here. At 1:12 a.m. on Saturday, March 15th, prior to the publication of the Alien Enemies Act proclamation, the ACLU filed a suit on behalf of 5 Venezuelan men facing imminent deportation under the AEA and moved for a temporary restraining order to prevent their removal. When Mr. Ruveni woke up that morning, he reviewed the plaintiff's motion and learned that the removals were allegedly to prisons in El Salvador, known for their torture and human rights abuses. I'm sorry, sometimes I forget I'm over on the tube and I can say those words. After learning from plaintiff's counsel that at least one plaintiff was reportedly already aboard a removal flight, Judge James Boasberg of the U.S. District Court for the District of Columbia entered an ex parte TRO prohibiting the government from removing the 5 named plaintiffs and set a hearing for 4 p.m., which the court later changed to 5 p.m. to hear arguments on a broader TRO. Right. Number 1, Deputy Assistant Attorney General Ensign willfully misled the court, while DHS and DOS ignored Mr. Ruveni's advice. Shortly after Judge Boasberg entered the initial TRO, Mr. Ruveni informed the district court via email at 10:18 a.m. that its order had been received and disseminated to the relevant executive branch agencies. At the 5 p.m. hearing later that day, DAAG Ensign represented the government in court, while Mr. Ruveni listened on the public line, emailing DHS and DOS agency counsel periodically. At this hearing, Judge Boasberg said that the plaintiffs expected planes to be departing within the last couple of hours and asked Ensign if any of the named plaintiffs are in fact on any plane that has departed. Ensign assured the court that none of the named plaintiffs would be removed during the pendency of the TRO. When Judge Boasberg asked if that meant the plaintiffs are either not on the planes or they will not be removed from the planes and will be brought back once the planes land in El Salvador, Ensign asserted, "I don't know the status of the planes. If there are removal flights, the 5 would not be on them." When Judge Boasberg asked whether any deportations or removals were imminent, as in the next 24 or 48 hours, Ensign answered, "I don't know the answer to that question." Mr. Ruveni reasonably believes Ensign's statements to the court that he did not know whether AEA removals would take place in the next 24 hours was false. Ensign had been present in the previous day's meeting when Emile Bove stated clearly that 1 or more planes containing individuals subject to the AEA would be taking off over the weekend no matter what. Ensign then added, "We can certainly investigate that and report that back to you." When Judge Boasberg asked how soon he could get that information, Ensign said the government could certainly include the information in a document they were planning to file tomorrow night. The plaintiff's lawyer stressed the urgency of the situation, noting his understanding from people on the ground from different sources that planes are going right now, taking Venezuelans to El Salvador, that 2 flights may have already taken off during this hearing, and urged the court to issue a class TRO now to avoid more harm. Oh my goodness gracious. I tell you what, you lose your reputation and your credibility as an attorney, and you're going to struggle for the rest of your days. At that point, Judge Boasberg adjourned the hearing until 6 p.m. to let Mr. Ensign do some digging. The court specified, "Mr. Ensign, I will want to know, have planes, in fact, is deportation of people under the proclamation pursuant to the AEA in motion now, and will it be for the next 48 hours? Ensign responded, "We can do that, Your Honor." The adjournment began at 5:22 p.m. Mr. Ruveni was not included in Ensign's conversations with DHS, DOS, and DOJ leadership during this period. However, prior to 5:24 p.m., DOJ attorneys, including Ensign and Mr. Ruveni, received an email from plaintiff's attorney citing public reporting of flight information and stating that they had reason to believe that people were on planes for imminent deportation. According to public reports and various websites that track the whereabouts of airplanes in real time, at least 2 planes took off from Texas after the start of the hearing, the first at 5:26 p.m. and the second at 5:45 p.m., en route to what online sources speculated was a final destination of El Salvador. Oh, it's so awful. It's so awful. To the 3 different hearings where Ensign lied. Yes, I was on those too. I was there too, and it was like he wasn't really even hiding it. He was just like, whatever. Yet at 6 p.m. following the 38-minute adjournment, DAAG Ensign provided Judge Boasberg with no information regarding flight departures, Specifically, Ensign told the court, "I don't have many details to share," explaining that his clients said that the operational details raised potential national security issues, particularly ones if discussed with the public line. When Ensign said that his clients raised that we may be able to provide your honor with additional details in an in-camera hearing, Judge Boasberg quickly arranged to disconnect the public phone line and start an in-camera proceeding. But even after the court accommodated that request for an in-camera proceeding, Ensign failed to provide information about the flights. Again, he explained that we would have to sort out what can still be provided in camera. They suggested that as a way to potentially provide some details, but I do not personally have those right now. Once it became clear that Ensign would not provide information, even in camera, the court ended the in-camera proceeding and reconnected to the public line. So that's such a jerk move. You're like, let's go to chambers, Your Honor. And then you go to chambers, you're like, let me think about it. Like, goodness gracious. Plaintiff's counsel told the court, "We understand that 2 flights went to El Salvador this afternoon, and that a third flight was scheduled for 6:23. So only in a matter of minutes, after several minutes of legal argument, the court found that the class certification is warranted." When a court issues an injunction against the federal government, the normal practice is for the Justice Department lawyers to work with the agency counsel in developing guidance explaining what the government must do to comply with the injunction. The relevant agencies then disseminate the guidance to their components. For example, when a court order impacts DHS immigration removal operations, in normal practice, DOJ and DHS lawyers create guidance that DHS would then, once approved, disseminate to Immigration and Customs Enforcement and removal operations and other relevant components. Because Mr. Ruveni's name was on the court papers the government filed in the 3 cases at issue, and because of his role as acting deputy director for oil, he had a responsibility to confirm that the government was abiding by the court orders in those cases. With this in mind, at 6:14, as the hearing continued, Mr. Ruveni again listened on the public line, emailed attorneys with the DHS Office of General Counsel, ICE Office of Principal Legal Advisor, and the DOS Office of Legal Advisor, informing them, along with other DOJ attorneys, that the judge is certifying a nationwide class as we speak. It's unlikely a class-wide TRO is imminent. At 6:44 p.m., Mr. Ruveni sent a follow-up email. Quote, "The judge is presently issuing a class-wide TRO. Can folks confirm for us if at the moment, any individuals subject to the AEA are being staged for removal or are presently in the air as part of removal, but not yet having landed and disembarked?" At 6:44 p.m., Mr. Ruveni texted his supervisor, Mr. Flienyi, referencing Beauvais' March 14th comment that it might become necessary to tell the court, "F you." Mr. Flienyi acknowledged Beauvais' comments with a joke, referencing the possibility that either he or Mr. Ruveni could be fired, impliedly for reporting up their chain of command concerns that a court order may have been violated. Oh my gosh. At 6:46 p.m., Mr. Ruveni emailed DHS substance of Judge Boasberg's oral order concerning class certification in a TRO. The class is all non-citizens in U.S. custody, subject to the AEA's minute order with more specifics will issue. Please confirm receipt of this email and let us know ASAP on the question below concerning removals not yet effectuated, including those involving folks in the air. At 6:48 p.m., Mr. Ruveni sent another email. "Sorry for all the emails. Last email, the judge specified ordered us to not remove anyone in the class and to return anyone in the air." After additional legal argument, Judge Boasberg stated, my goodness, a TRO is appropriate for the class members, prohibiting removal of class members, with the class consisting of all non-citizens in U.S. custody who are subject to the proclamation of March 15th and its implementation. Judge Boasberg explained that the court was required to act immediately and could not wait any longer, particularly in light of the plaintiff's information, unrebutted by the government, that flights are actively departing and plan to depart. instructing Ensign, "You shall inform your clients of this immediately, and that any plane containing these folks that is going to take off or is in the air needs to be returned to the United States. But those people need to be returned to the United States. However, that's accomplished. Whether turning around a plane or not embarking anyone on that plane or those people covered by this on the plane, I leave that to you. But this is something that you need to make sure is complied with immediately." Not a lot of questions about the language here. At 7:04 p.m., Mr. Ruveni emailed DHS and DOS as follows: "As we await the written order clarifying our understanding of the injunction as clarified at the end, no one subject to AEA in our custody can be removed, and anyone in the air should be returned unless they have a Title VIII final order. Please confirm receipt and let us know what, if anything, is happening. Thank you." DHS and DOS attorneys did not respond. Mr. Ruveni followed up with DHS at 7:18 p.m., requesting confirmation that no one without a final order of removal under Title VIII would be removed from the planes as they landed, including one scheduled to land at 7:20, noting that we need to address this ASAP to avoid contempt. Mr. Ruveni again received no response. Oh my gosh, this is so awful. At 7:26 p.m., the court issued a minute order memorializing its TRO. At 7:27, Mr. Ruveni sent another email to DHS and DOS with a copy of the minute order. At 7:31 p.m., Ensign emailed James Percival, senior counsel to the Secretary of Homeland Security, and Joseph Mazzara, acting general counsel for the Department of Homeland Security, informing them of the injunction, and 2 minutes later emailed DOS counsel. Both of these emails, on which Mr. Ruveni and Flentier were copied, informed the recipients that both the oral and written injunctions informed the agency counsel that their clients were required to not remove anyone within the class definition, and reflected that Ensign understood the judge to be requiring that DHS not deplane any planes that had departed U.S. Airspace. Mr. Ruveni was not copied on any response. At 10:13 p.m., after he and Mr. Flentier had exchanged numerous emails and he had no information about a DHS compliance, Mr. Ruveni again emailed DHS to ask about whether guidance had been disseminated with direction for DHS to turn any planes around if not yet landed, or to not deplane the people on board if already landed. Yeah, he's in a tough spot here, everyone. He's in a pretty tough spot. Shortly thereafter, DHS responded via email that they were holding issuance of guidance pending a decision from the Attorney General. Number 2, Emile Beauvais advised the Department of Homeland Security that it may take actions that violate the court's injunction because the injunction was not yet issued in writing. That's such crap. That's such crap. For the next few hours on the night of March 15th, Mr. Ruveni exchanged emails with Flentier and engaged in multiple phone calls with Ensign. He was concerned about 2 things. 1, that deplaning any passengers would violate the court's order, and 2, the need to notify the court of the government's compliance with those orders or its interpretation of the orders. Sometime around midnight, Ensign informed Mr. Ruveni that the DOJ would be filing a notice with the court, signed by Beauvais, explaining its interpretation of the court order, including that no violation of the court order had occurred because the 2 planes left U.S. airspace before the court's written minute order. Ensign directed Mr. Ruveni to prepare Beauvais' notice of appearance, while Mr. Ruveni disagreed with the interpretation that there was no violation of the court order. The fact that Beauvais, a senior DOJ official, was willing to enter an appearance in the case and make this representation to the court somewhat lessened his concerns, because he believed he and his staff would not be put in the untenable position of defending this argument. That quickly changed on Sunday, March 16th at 12:23 a.m. Ensign informed Mr. Ruveni by phone that Beauvais would no longer be filing either a notice of appearance or notice to the court explaining the government's interpretation of the court's order. Thereafter, Mr. Ruveni and Flentier exchanged several more emails. Mr. Ruveni anticipated the government would be held in contempt of court for deplaning those on the flight and communicated his belief that a notice to the court was necessary. At 12:33 a.m., Ensign telephoned Mr. Ruveni, informing him that DOJ leadership did not appear to be in a hurry to file such notice. Mr. Ruveni responded that the government would likely face a show cause motion seeking an explanation as to why the government should not be held in contempt of court, which is exactly what happened. That is exactly what happened. That same morning at 8:07 a.m., Mr. Ruveni emailed DHS and DOS asking for confirmation of their compliance with Judge Boasberg's oral and written orders, specifically asking for the status of individuals on each of the previous day's 3 flights. Mr. Ruveni's email included a reminder that to comply with the injunction, no one subject to the AEA removal should have been deplaned, and anyone who had been deplaned needed to be returned to the United States. Mr. Ruveni also asked whether conversations on these issues were happening at a higher level of leadership between and among DOJ, DHS, and DOS. Mr. Ruveni received no response. Given the absence of any email or notice from the agencies or DOJ leadership at that point, Mr. Ruveni's concerns from the prior night that DHS had been directed to violate the court's order began to escalate. Early in the morning of Sunday, March 16th, President Bukele of El Salvador posted a comment on social media stating, "Oopsie, too late." God, that's such a... in reference to Judge Boasberg's order, and Secretary of State Rubio's reposted the comment soon after. Soon after Bukele's initial comment, Bukele posted a video of men being escorted from planes into the Terrorism Confinement Center prison. Oh my goodness gracious. Christy Noah media team was already... I know, right? Ugh. As the day continued, Mr. Ruveni's emails asking for confirmation of the status of the removal flights remains unanswered. Mr. Ruveni reported his concerns to Auguste Flentier that based on public reporting social media posts of the Secretary of State and the President of El Salvador and the failure of DHS to answer any of Mr. Ruveni's questions concerning the 3 flights that had taken off the previous day, it appeared the government had violated the court's order and removed individuals to El Salvador. Eventually, agency counsel for DHS informed Mr. Ruveni by telephone that DOJ leadership has advised DHS to deplane the flights in El Salvador, and directed Mr. Ruveni to consult DOJ leadership if he had any questions. Through the course of the events on March 16th, it became clear to Mr. Ruveni that DHS and DOS were receiving contrary directions from someone else to take actions in violation of court orders. By 2 p.m., the identity of that individual became... Oh, hello, Kristen. Welcome. Clear in an email from Acting Assistant Attorney General Yakov Roth, oh my gosh, the Yakov Roth fella, to Ensign Flentier and Mr. Ruveni, Roth explained that Bove had advised DHS under the court order it was permissible to deplane individuals on the flights that departed U.S. airspace before the minute order had issued on the docket. That afternoon, the Department of Justice filed a notice indicating that defendants were promptly notified of the court's temporary restraining order issued in the morning and the 7:26 p.m. minute order that temporarily enjoined any removals pursuant to the presidential proclamation. The notice also asserted that some gang members subject to removal under the proclamation had already been removed from the United States territory under the proclamation because of the issuance of this court's second written order. By day's end, multiple media reports and postings from senior government officials in both the United States and El Salvador and social media confirmed that all individuals on 2 of the 3 planes that had taken off on March 15th had been detained in the Secot prison in El Salvador. The next hearing in the case occurred Monday, March 17th. At some point prior to the March 17th hearing, Ensign informed Mr. Ruveni that Ensign would not be handling the hearing, given concerns that the court would likely interrogate Ensign concerning the March 15 events. So he was saying, I'm not going to go into court because the judge is going to ask me questions. Yeah, coward. Number 3, government refused to comply with the court's reporting order. On March 17th, the court held a hearing to determine whether the government complied with its orders. The court issued a minute order determining that demanding the government state whether and if in what form it would provide answers to the court's questions regarding the particulars of the flights. The order further stated that if the government takes the position that it will not provide the information to the court under any circumstances, it must support such position, including with classified authorities if necessary. Following this order, a Flenti and Ensign told Mr. Ruveni that leadership at DOJ were reporting down the chain that the government was not going to answer the court's questions about anything that happened before 7:26 p.m. on March 15th. And so not to provide information about when the flights took off. Man, these people are such, oh my gosh, it's just awful, awful. Attorneys behaving badly here. DVD versus DHS, Mr. Ruveni advised that injunction against third country removals without torture screenings applied nationwide, but government removed people in violation of the injunction nonetheless. The second case in which Mr. Ruveni exercised his right to make protected disclosures unfolded over the weekend of March 28th through the 30th. This case involved allegations that DHS had begun removing individuals with final orders of removal to third countries without first ascertaining whether such individuals would be safe in those countries or potentially tortured as required by the Convention Against Torture, which is CAT. On the afternoon of Friday, March 28th, around 2:30 p.m., Judge Brian Murphy, United States District Court judge in the District of Massachusetts, issued a nationwide TRO, the order enjoined the government from removing the 3 named plaintiffs and any individual subject to a final order removal from the United States to a third country, a country other than the country designated for removal in immigration proceedings, without providing the individual and their counsel with written notice of the third country to where they might be removed, and a meaningful opportunity for that individual to submit an application for CAT protection to the immigration court, and if such application is filed, until that individual receives a final agency decision on such application. All right, so now we're into the DVD case. Oh my goodness gracious. Friday, March 28th, senior leadership took the position that the injunction did not have nationwide applicability despite DOJ Oil's instruction. DOJ leadership determined to seek an immediate appeal and stay of the order. The argument for the emergency stay in the appellate brief was that the TRO, which by its terms applied nationwide, was impermissible under the Immigration and Nationality Act, and in any event had to be limited to the named plaintiffs. Curiously, McHenry, counselor of the Deputy Attorney General, directed through Ensign that afternoon that it was necessary to include a peculiar footnote with no context stating, quote, the operational effects of the order is ambiguous. Oh my gosh. Over the course of the afternoon and evening of Friday, March 28th, it became apparent why McHenry had insisted on including this odd footnote. First, Mr. Ruveni learned that DHS was directed by someone within the administration unknown to Mr. Ruveni not to issue guidance to its officers concerning the fact of and terms of the injunction. This was despite the fact that DHS agency counsel had drafted guidance concerning the injunction that noted the nationwide applicability of the TRO, which Mr. Ruveni and others at Oil had agreed was appropriate. Mr. Ruveni sent multiple emails to DHS counsel requesting updates regarding when the guidance would be disseminated. Multiple line attorneys at DHS alerted Mr. Ruveni that the guidance was never distributed. Ensign eventually told Mr. Ruveni that the Office of the Deputy Attorney General had directed a hold on dissemination of the guidance as they were reviewing it, an unusual but not unheard of level of review. On March 28th at 11:28 p.m., Mr. Ruveni sent an email to DHS counsel noting his understanding that guidance had not yet been issued, as Oil had advised, and asking for confirmation whether anyone subject to the injunction was being staged for removal. Mr. Ruveni noted that the government's briefs argued in requesting an emergency stay that the court order applied broadly beyond named plaintiffs. In response, at 12:34 a.m., Senior Counsel to the Secretary of Homeland Security, James Percival, responded to DHS that my take on these emails is that the DOJ leadership and DOJ litigators don't agree on the strategy. Please keep DHS out of it. Mr. Ruveni responded at 12:36. What is the position? To which Percival responded at 12:38. Ask your leadership. What? With this clear disconnect, it was evident to Mr. Ruveni that DHS had received direction contrary to the guidance of OIL that OIL had provided concerning the scope of the injunction. Mr. Ruveni had attempted to contact Ensign and Flentier multiple times by phone between 10:40 p.m. and 12:04 a.m. and Roth via email, but no one answered. This is such a terrible, terrible situation. So let's dive in here to the night. So the night of March 28th, morning of March 29th, White House directed Mr. Ruveni to file brief asking for emergency stay with assurances of understanding of nationwide applicability. Mr. Ruveni, unable to contact his chain of command, made the decision that the brief requesting an emergency stay could not be filed, given the lack of consensus that the injunction applied nationwide, and notified DHS at the same at 12:42 a.m. on Saturday, March 29th. 12:50 a.m., Mr. Ruveni received frantic emails from multiple senior DOJ and DHS officers, ultimately including McHenry Perkins, counselor of the Attorney General Henry Whitaker, and Percival, asking him to call them. Mr. Ruveni first called ADAG Perkins, and he and McHenry were on the line. They asked Mr. Ruveni why the brief had not been filed. Mr. Ruveni explained that per his email, there seemed to be a fundamental disconnect between the brief, which acknowledged nationwide applicability of the injunction as the basis for seeking the emergency stay, and DHS's understanding that the injunction only applied to 3 named plaintiffs. On the call, Mr. Ruveni perceived McHenry to be acting strangely, answering questions evasively, and suggesting additional odd language to add to the brief. Neither Perkins nor McHenry confirmed whether ICE had even received the text or the injunction. The call ended with McHenry said he and Perkins needed to go make a call and we'll be back in touch. Oh my gosh, it's just so suspicious. Around 1:18 a.m., Whitaker and Percival emailed Mr. Ruveni asking him to call them. Mr. Ruveni called Whitaker, who immediately passed it to Percival. Similarly to McHenry and Perkins, Whitaker and Percival asked Mr. Ruveni why the brief had not been filed. They stated that the White House wanted the brief filed by midnight. Mr. Ruveni stated that DHS seemed to be saying that DOJ leadership was giving them guidance contrary to that provided by OIL. He explained that the brief acknowledged the injunction applied nationwide, but DHS's position was that it only applied to 3 named plaintiffs. Mr. Ruveni explained to Whitaker and Percival that if the brief were filed acknowledging nationwide applicability of the injunction, that would be the official position of the United States. If there were also removal flights planned for the weekend, they would have to be consistent with the injunction or risk contempt of court. If removals inconsistent with the injunction were effectuated nonetheless, the government would have to withdraw or modify its brief and notify the court. Mr. Ruveni also shared his understanding that no guidance had been disseminated to DHS regarding the position in the brief. Mr. Ruveni asked Whitaker and Percival if they agreed that the injunction required nationwide applicability. Percival hurriedly responded, "Yeah, sure," and Whitaker said, "Yeah, buddy." Oh my goodness gracious. Still concerned by relying on the assurances from Whitaker and Percival that they agreed the injunction applied to more than just 3 named plaintiffs, Mr. Ruveni directed his staff to file the brief. Later that day, Mr. Ruveni learned with certainty that DHS had never disseminated the injunction or guidance about its applicability within the agency, and that's a huge issue. Oh my goodness. Yeah, I hope you did take notes as well. It sounds like you did. I mean, it sounds like this is pretty well documented. So there's lots more great stuff here, everyone, but in the interest of my voice, I'm going to skip ahead here to kind of the closing piece of this. So we've got Saturday, March 29th, a gag order was instructed to stop asking about the injunction compliance guidance. Like, you need to stop asking us that question. Then Sunday, March 30th, Mr. Ruveni reported a possible violation of the injunction. March 31st, evidence demonstrated the government violated the injunction. He's going to be an incredible witness here. And then C, Kilmar Abrego Garcia, wrongful removal with unsubstantiated gang allegations. Government made legally erroneous claims that withholding of removal can be revoked without due process. And then he goes in and explains that. Which no attorney would do. No decent attorney would say no due process. That's just not how it is. Mr. Ruveni took on Abrego Garcia's case where the government's records show Mr. Abrego Garcia was erroneously removed. On March 31st, senior counsel to the Secretary of Homeland Security, James Percival, asked whether the government could allege Mr. Abrego Garcia was the leader of MS-13 without evidence to support the allegations. No, don't do that. Oh my goodness. Oh my gosh. Come on, really? All right, let's read this piece because I think this one looks pretty major, everyone. Let's dive into this one. Right. Plug in. I know. I've got a pretty good idea of how much time I've got left, but I just be a little careful. All right, let's just read through these couple of paragraphs here. By at least March 27th, in communication with DHS, DOS, and DOJ counsel, questions were raised regarding the existence of evidence that Mr. Abrego Garcia was a gang member and why he was included on removal flights to CCOT. DHS could not provide direct evidence of Mr. Abrego Garcia's alleged MS-13 gang affiliations. Boom, everybody. Boom right here. An attorney in the middle of it asking for evidence. They didn't have any. That's huge. That's huge. No worries. But this can be used in a civil lawsuit. All right, this piece of it. Then on Monday, March 31st, the day the government's brief was due, senior counsel to the Secretary of Homeland Security, James Percival, asked whether the brief could make a number of factual allegations, including that Mr. Abrego Garcia was an MS-13 leader. Mr. Ruveni noted that such factual allegations would need to be supported by evidence, such as a declarant on behalf of DHS. Oh my gosh, this is where they're clearly framing him. Approximately 2 hours after the exchange between Percival and Mr. Ruveni, DHS provided a declaration. The declarant was Robert Cerna. Dun, dun, dun. Oh my gosh. Acting Field Officer Director for Enforcement and Removal Operations at Immigration and Customs Enforcement. Through Cerna's declaration, DHS conceded that because Mr. Abrego Garcia had obtained withholding of removal protection, DHS had no legal authority to remove him to his home country of El Salvador. Nonetheless, Mr. Abrego Garcia was, according to Cerna, placed on a plane to El Salvador. Cerna stated that ICE was aware of this grant of withholding of removal at the time of Abrego Garcia's removal from the United States, and that reference was made to this status on internal forms. But yet, through administrative error, Abrego Garcia was removed from the United States to El Salvador. This was an oversight. Cerna also could not personally confirm and declined to attest to Mr. Abrego Garcia's gang membership, let alone his status as an MS-13 leader. Instead, Cerna's declaration stated Mr. Abrego Garcia was removed on March 15th based on his purported membership. In MS-13, Cerna's declaration was included as an exhibit to the brief submitted to the court on March 31st, along with the decision from immigration adjudicators referencing MS-13 gang allegations, but lacking in direct supporting evidence of those allegations. So the attorney himself was like, you don't have the evidence. Oops, sorry everybody. You don't have the evidence to do this. What are you doing? Sorry, my battery pack. All right, we'll go to battery pack number 3. Oh my goodness gracious. This is so awful. This whole situation is just so, oops, that's the wrong one. So awful. All right, just 1 second here. Okay. There we go. Woo, we're back in business. Back in the business. From being fired. Oh my gosh. I tell you what, that's exactly what's going on here. That's exactly what's going on. They are framing this person so that it doesn't look so bad for them. And because for some reason, this Abrego Garcia person had offended. I'm wondering if he just offended somebody and they're like, we're going to go for him. Like, I don't know. But it's pretty atrocious here. All right, next piece. 3, Mr. Ruveni raised concerns about sufficiency of the evidence, urged remedial actions to address Mr. Abrego Garcia's erroneous removal. And again, we're going to kind of fast forward through this here. After Mr. Ruveni repeated in court, per the record, the government's concession that Mr. Abrego Garcia was erroneously removed, Ensign asked Mr. Ruveni for the first time why he did not argue Mr. Abrego Garcia was a terrorist. Wow. He's like, why? Oh my gosh. All right, let's just grab what happened after the hearing here. A few minutes after the hearing, Mr. Ruveni went from the courtroom to the U.S. Attorney's office space in the court building. The press had been present at the hearing, and by the time he was leaving the courtroom, Mr. Ruveni had already received multiple text messages sharing news headlines about his statements in court. Mr. Ruveni also received an email from Ensign directing Ruveni to call him, which Mr. Ruveni did. On that call, Ensign asked Mr. Ruveni for the first time why Mr. Ruveni had not argued that Mr. Abrego Garcia was a terrorist and that therefore his withholding of removal order was invalid. Mr. Ruveni told Ensign words to the effect of, I understand you've seen the headlines, but read the transcript. I did not say the things the headlines say that I said. Ensign asked Mr. Ruveni why he didn't argue Mr. Abrego Garcia was a member of a terrorist organization, or that being a member of such organization meant Mr. Garcia's protection from removal was nullified. Mr. Ruveni told Ensign he did not make those arguments because, and here we go, number 1, those were not arguments in the government's brief, which Ensign had reviewed, and 2, there was no evidence in the record to support those arguments, and 3, the laws governing withholding of removal do not support the theory that declaring someone a member of a terrorist organization retroactively nullifies a grant of withholding relief. And that's it right here. This is the whole bits and bobs right here. Ensign had little reaction, but called again a few minutes later asking similar questions and informing Mr. Ruveni that these inquiries were prompted by the White House. Mr. Ruveni again repeated the same concerns he had on the first call. Yikes! Fast forwarding again. So they're like, why didn't you argue that he was a terrorist? Well, I have no proof that he was. And that's not even relevant. They're like, well, do it anyway. Next, Mr. Ruveni refused to sign an appeal brief with arguments unsupported by evidence or law that was put on by administrative leave in retaliation for his protected activity and refusal to obey an illegal order. Oh my gosh. Unlawful retaliation set here. So, here. Ooh, let's look at that. In reprisal for his whistleblowing and refusal to obey illegal orders, Mr. Ruveni was placed on administrative leave on April 5th, removed from federal service on April 11th, both violations of 5 U.S. Code Section 2302. The Whistleblower Protection Act, among other protections, prohibits federal agencies from taking retaliatory personnel actions against employees who raise whistleblower concerns internally and who refuse to obey illegal orders. This is no question here, particularly based on the administration's own statements that these actions taken against Mr. Ruveni were meant to silence Mr. Ruveni and other DOJ attorneys who resist unlawful actions. Oh my gosh, it's definitely effed up. It's definitely effed up. Oh, it's really bad. This is really bad. here's our conclusion, everyone. So let's land the plane. I mean, maybe that's a bad choice of words. Well, let's get to the conclusion here. Mr. Ruveni refuses to stay silent despite the retaliation he has already faced and the serious risk of additional retaliation for his choice to continue to exercise his rights by disclosing to Congress the DOJ Inspector General and Office of Special Counsel information about senior DOJ and White House leadership's intent and actions to defy the rule of law. The consequences of the DOJ's actions, Mr. Ruveni reports, have grave impacts not only for the safety of individuals removed from the country in violation of court orders, but also for the constitutional rights and protections of all persons, citizens and non-citizens alike, who are potential victims of flagrant, deliberate disregard of due process and the rule of law by the agency charged with upholding it. Oh my gosh. Mr. Ruveni does not make these disclosures lightly. In his disclosures, he's carefully exercised his rights under the Whistleblower Protection Act to report serious illegality and abuses of power consistent with and in compliance with the rules of professional conduct. Mr. Ruveni remains committed to the rule of law and to his oath as an attorney and as a nonpartisan civil servant he swore when he joined the Department of Justice in 2010, and that he has carried out across the administration. So here's the oath, everyone. Here's the oath that we all take when we come into a government service, all right? We all take it. I, Arez Ruveni, do solemnly swear that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, that I will bear the true faith and allegiance to the same, that I take this obligation freely without any mental reservation or purpose of evasion, and I will well and faithfully discharge the duties of the office on which I am about to enter, so help me God. We all take this oath. Everybody does. We ask the members of Congress, the DOJ Inspector General, and the leadership of the Office of Special Counsel remain similarly committed to their oaths of office and discharge their duties of oversight and accountability without fear or favor. Oh my gosh. I know, right. All right, so we made it to the end here. So what are our thoughts? What are we, how are we feeling about this? This was incredibly well written, I thought, in front of so many lawyers. Yeah, exactly. I think the closing was very well done. Right, very well done. This isn't TikTok. Oh, I know, Jenny. I know. It takes a little bit to get used to the switch. For sure. Arrest them. Right. I think it's well written too. So one of the things that, I've been saying during this whole Iran situation is that we can't stop the pressure on the domestic issues that we're talking about, right? We can't get that tangled up so that it gets brushed under a rug. And people have been saying, like, well, what can we do that's more? I would say at this point, I'm wondering, do we have, we're not even in an ethics violations world. We're even outside of the ethics violations situation. So I would say at this point to go forward and send your letters, send your information that you're saying, we've gone through this information, and send it to these people right here specifically. Send it to the Senate and send it to the House of Representatives. And, just say, hey, what are you going to do about the whistleblower situation? What's going on with that? Call them, send them whatever. But to target the people named in this, like Beauvais and, the other fellas, target them and send and call to the leaders here of the Judiciary Committee. They're the ones with the power at this point. They're the ones that can help to check the situation. They could impeach the Attorney General. They can pull people out of their positions in the DOJ. They can pull funding. So this is where the power is with these 4 people right here. So this is where I would say send your questions. Send your questions, everyone. pull your people out of here. So we're talking about, Bove and those peoples. Pull the names out of here. Can he be impeached? He's a deputy at this point. So I'm not sure if impeachment's the right road, but he can be removed. I think he can just be fired. I think that's how he would get removed. If he was appointed and went through the Senate, that would be the impeachment. Can they get federal charges? Yes. Will they? We don't know, because if you put a federal charge against anybody right now, then, there could potentially be a pardon. I don't know if there actually will be a pardon, because Mr. Orange is off his frickin' rocker. So we don't know if that's like something he would do or not. It depends on his mood. But yeah, there can absolutely be federal charges brought in here. And as long as we're within the statute of limitations, they can wait too. We can wait it out until after midterms. And this goes slow. This is a slow process, but it's powerful. And that's why too, when we're documenting at this level of detail, documentation is going to be amazing for anybody pulled into these lawsuits that have had to deal with this stuff. All right. Yes. Could states file lawsuits based on this? It's possible. It's possible. We're dealing with federal law in the federal immigration process. I'm not sure how the AG's offices in different states could come in, other than to say that the policy is being done improperly. They could go after Bondi as well to support people to put an impeachment article up. So yeah, it's possible. Our state AGs have definitely been doing some stuff. Fire for people. Oh, I know. Thank you. Oh, you're welcome, Charles. Thanks for coming by tonight. Yeah, this is really bad. This is pretty bad. We'll see. And this is just the beginning. I mean, this is going to be going on and on and on. This takes so long for this to happen, but the process is slow but thorough. And again, I believe there's hearings tomorrow. I can't remember exactly where I read that, but I think this is important. I'm not sure if it's Bove that's being pulled in. It might be Bove or who, but we're supposed to be having some hearings tomorrow. So this is so relevant right now. Okay, it's Bove. Oh, thank you, Willie B. Thank you so much. Oh, Bove. Yeah. Oh my gosh, he's such a blah. Thank you for all you do. Oh, no problem. Oh, I'm happy to help. And, just kind of walk through what this language and stuff means exactly, and what's okay and what's not okay. Been continuous for me. Yeah, so he's the deputy chief of whatever now. So if you're a deputy, I'm not sure if you're appointed if you're a deputy. I think you're pulled in by your boss. And so that's just a regular position that's not protected. So I'm not sure it would be an impeachment. He's been nominated for, an appeals court judge. Right. Yikes. Well, and that's stupid. One of the questions should be asked is, well, if you get on the bench, you're immediately going to be impeached by your behavior. In all of these cases, there's so many cases here. He's got an ethics violation against him for the New York situation, where they were making promises as long as immigration was being upheld. He's got those issues. He's got all of his involvement in these cases, the habeas corpus cases. He's got a lot that could potentially lead to impeachment. So if he was a judge, you don't have to get impeached for your behavior there. You can have these questions raised to you for prior behavior. Right. Ethical attorneys around. I think they're just attracted to the light, I think they there's good and bad people, and I think bad people find each other, right? Or if you're on the cusp, if you're one way or the other and you get really mad one day, it's like you can fall down to the dark forest, right? We're in Star Wars land. Feed your hate. Go down the Emperor Road, right? Oh my gosh. Yeah, it's a lot. All right, my friends. With that, I will go ahead and let you go tonight. This was, I think, really important to go through this information, and we'll be able to see tomorrow how that's used during his questioning. So that should be an interesting take on things. But with that, again, everyone, thank you for coming by and hanging out with me over here on the tube, on our Tube and Tuesdays. We got lots of information to talk about and much more relaxed over here, which I really, really enjoy. So, again, I will continue to try to do Tuesdays. That's my goal over here, at least once a week to do Tuesdays. Hopefully, it works for me, but if it doesn't, I apologize. And I will put a note up. So, hopefully, I'll see you all again next week on the tube, and I will be over on the TikTok if there's anything that's kind of like breaking. So that's where I go for it, the quick lives over there. So again, thank you all for coming, and I appreciate your time and energy, and to all of my moderators, of course, thank you so very, very much. So have a great night, everybody. Take care, and I'll see you all again very soon.